Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a civil law case, and the point is whether notice under section 80 CPC has to be given even for amendment of the plaint in a case of continuous cause of action. Honorable Supreme Court of India held that no, not necessary. Justice Bela M. Trivedi and Satish Chandra Sharma in the case of the State of West Bengal versus PAM Developments Private Limited, SLP number 11,392 by 2024, decided on 9/1/2025. They held that giving notice under section 80 CPC is a different aspect, that is a protection to the government officers to take up the matter, to settle the matter in the cooling period of 2 months. But for amendment, that notice is not necessary. Right, friends, all of you are well aware, particularly the final year students, you know that section 80 CPC is a protective provision to the government officials. If you want to file a case against any of the government officers, maybe the superintendent engineer, maybe the chief secretary, even maybe the president, then you have to give an advance notice of under section 80 of the CPC. Wait for 2 months, then only you can institute the civil suit. Why this 2 months period? Because to give them breathing time. The government officers, maybe the superintendent engineer, maybe the collector, maybe sometimes you may be seeing in some cases municipal commissioner, municipal office jabtu chesamantaru. So you have to give them some cooling period. What for? Because they are not doing it for their personal benefit. They are doing it maybe in the interest of the public, maybe an excessive step. When that is the case, when some case is about to be filed against them, they have to consult their superiors. And the superiors should find time. They have to think over the matter. For that, 2 months time is given. Likewise, for execution, 3 months time is there. So this is a protective provision to the government officials under section 80 of the CPC. If you go to the details of the case, you will better understand it in a better way. Now, PAM Depot. The Superintendent Engineer, Public Works Department, he has floated a tender, or he has called for tenders for developing or for strengthening Howrah-Amta Road, AMTA, right, on 4/12/2013. So the so-called tender was published in the newspapers. And as per the tender, so final date, then the bidders have come, auction has started, and the final bid, the persons who are succeeded, they are PAM Developments Private Limited. That company, they got the bid. They were succeeded on successful on 23/4/2014. Yeah, 2014. Okay, they were successful. They got the bid, but they could not complete the work within the stipulated period of 1 year, I think. They have to complete it by 19/8/14. That means 4 months time was given. They could not complete. But once again, it was extended up to 1 year. That is 14/5/2015. But the work is not completed. Therefore, the deposit has been forfeited. Right? Panchayila. Cheynappudu government em chestadi? So, Kani on 7/7/2015, they were kept in the blacklist or debarred. Debarment of the so-called PAM Developments. In this connection, they went to the court. Of course, they said that we are not at fault because of the hike in the prices or something. This happened like this. So they have given a stay. High Court has given a stay orders. This matter has been continuing, right? So the debarment of so-called people, they have been kept aside, right? So please remember, Actually, as per the directions of the court, the department committee has been formed and they asked both the parties to appear before them. Against this, the court, the government department, they filed a suit. Ultimately, since the amount is not, because the PAM developments వాళ్ళు వర్క్ కంప్లీట్ చేయలేదు, అయినా కొంత ఖర్చు పెట్టారు కదా, వీళ్ళేమి ఇవ్వట్లా, పైగా డిపాజిట్ అమౌంట్ని తీసేసుకున్నారు, మాకు ఇంకా అప్పులు ఉన్నాయి అని చెప్పి దే ఫైల్డ్ ఎ కేస్. సో దట్ ఈస్ ఓఎస్ నెంబర్ 102/16 రికవరీ సూట్ ఫర్ రికవరీ వేసారు. ఓకే, బాగుంది. సూట్ ఫర్ రికవరీ వేసినప్పుడు ఈ పార్టీస్ ఎవరు? గవర్నమెంట్. కాబట్టి 80 CPS కింద నోటీస్ ఇచ్చారు. ఇచ్చిన తర్వాత సబ్సిక్వెంట్గా వీళ్ళు బ్లాక్ లిస్ట్ పెట్టారని, పెట్టలేదని, ఆ తర్వాత చాలా గొడవలు ఉన్నాయి. సో కాబట్టి సబ్సిక్వెంట్ డెవలప్మెంట్స్ కూడా దే వాంటెడ్ టు file an amendment for the subsequent developments, and court said yes, when the suit is not disturbed, and structure of the suit is not changed, plaint is allowed. Kani, the advocate on behalf of the government, he said that notice has to be given to the government under section 80 CPC. Idanamata. Several facts that took place after the OS was filed, so it comes under continuous cause of action. So it's not a fresh claim, it is a continuation. So therefore, the Honorable Supreme Court of India referred to Order number 23, Rule numbers 1 and 4 of the CPC, and said that no, it is not a fresh suit. So therefore, amendment can be allowed. High Court is correct. You need not give the notice under section 80 of the CPC. CPC ఫాలో అయ్యే వాళ్ళకి అర్థమవుతుంది. మిగతా వాళ్ళు ఏంటి బోర్ అనుకోకుండా జాగ్రత్తగా 1-2 సార్లు వినండి, మీ కేసు అర్థమవుతుంది. Advantage to the government. Okay, here I am stopping. Thank you very much.